started. I have some talking points before I start introduction. So by 11:35, we'll be launching into an introduction. So welcome to our monthly advocacy and action event. We have this event every month. It was created as a free opportunity for families and self-advocates, educators, and professionals seeking knowledge to be empowered to better serve the students or their children with disabilities. So knowledge is power. We're going to be hosting these monthly. We have been. This is starting our second year of hosting these events now. So thanks so much to RAC and to Sadie for offering the space up. These events occur on the fourth month or the fourth Thursday of the month, but we rotate the time. So it's either going to be at 9 o'clock, 11:30 like today, or 3:30 to offer different opportunities for people to access the event. We also record and share the event so that if families are not able to join for any reason, that they can access it at their convenience. Feel free to share the flyer, the recordings, the Padlet. All of this is available to families so that they have resources at their fingertips. So please, if you know anyone who's struggling with navigating the systems, even someone who does not have a child on an IEP, but maybe suspects that their child has a disability, this is the right space for them in terms of the supports that they could find. I'll wrap up the event and give some more information about our next event. But if you have to leave early, I just want you to mark your calendar that our next event is on March 26th from 3:30 to 5 o'clock. And this is in honor of Disability Awareness Month. And we're going to be featuring some organizations to highlight disability awareness and just resource navigation. So we have commitments from Hamilton County Developmental Disability Services, the ARC of Ohio, and the Southwestern, oh goodness gracious, and Sadie's off, but it's SWOCOG, if you know what that stands for. Council of Governments. I failed, guys. I can't remember what it stands for, and I'm so sorry. But by next month, I promise you I will know what that stands for. I always call it SWOCOG. Anyway, I'm going to launch into the introductions next. So I am so delighted and appreciative that we have the Knowledge Trust here that we have today. These are all ladies that I have a great respect and fondness for and have worked with them directly in a variety of ways and can attest to the high quality and high character that they represent. So Ashley Barlow's passion for special education advocacy stems from her experiences as a general education teacher and from advocating for a more inclusive educational placement for her son Jack, who has Down syndrome. She has attended and presented at many national conferences for special education attorneys and advocates, including the Institute of Special Education, and she also holds an advanced advocacy certificate from the Council of Parents, Attorneys, and Advocates, and she is on the State Advisory Board for Exceptional Children in Kentucky. Ashley owns a law firm, Meyer and Barlow Law Firm, that focuses on special education and special needs estate planning, as well as an online business, Ashley Barlow Company, which was established to empower IEP team members via a podcast, online courses, and many other resources. Prior to practicing law, Ashley was a teacher in Jefferson County and Cincinnati public school systems and a professor at her alma mater, Miami University. Ashley attended Salmon P. Chase College of Law. When not working, Ashley is normally at the pool with her husband and two sons or grabbing a coffee in her 1975 Volkswagen bus. That's fun. Next, we have Jenny Godby. So Jennifer Godby is a dedicated non-attorney special education advocate based in Cincinnati, Ohio. She empowers parents and students to navigate the complexities of the IEP process within public schools. With a passion for ensuring equitable access to education, Jennifer works closely with families to understand their rights, develop effective IEPs, and foster collaboration with school staff. Her goal is to create a supportive environment where every child can thrive and reach their full potential. And then we have Sarah and Stephanie. So Sarah Flora is a senior supervising attorney at the Legal Aid Society of Greater Cincinnati. And Stephanie Mose is the director of the Legal Aid Society of Southwestern Ohio, an affiliate of the Legal Aid Society of Greater Cincinnati. Their organizations provide free legal help to low and moderate income parents and students throughout Southwest Ohio to ensure schools follow special education and disability laws, identify disability related needs early, and put the right supports in place. A core part of their work is preventing unnecessary suspensions and expulsions by advocating for appropriate services and representing students and parents in discipline hearings. So thank you for those excellent introductions. There is so much more to all of these ladies than just those introductions, I'm here to tell you. And we're going to get started by, if I can just put some of you on the spot. Yep. Can we help navigating 504s? Oh, thank you, Ashley, the Southwestern Ohio Council of Governments. Thank you so much. So it seems like the first question, and Ashley and I were actually just at an event yesterday, so maybe you can just quickly highlight for us, Ashley, the difference between a 504 and an IEP. And the first question is, can you help with navigating 504s? It's also one of the questions that I was planning on bringing up during this.
Sure. Yeah, I'm happy to. I told Amanda that I would try to talk less today. So and then she hit me right off the bat. Um yeah, so the difference between 504s and IEPs, so the answer to Tyler's question is yes. I think probably all of us can help with 504 plans. Okay, so think about IEPs first. And Amanda, I'll try to do this faster and shorter than I did yesterday. So what an IEP does is an IEP provides, I like to say, skills, strategies, and supports, but most importantly, instruction for students that have a disability. Now, the big caveat to getting an IEP is eligibility, like the process to get an IEP is a two-part process. First, you have to have a qualifying disability. The federal law IDEA, Individuals with Disabilities Education Act, has 13 disability categories, and states have more. They can have more if they want. They can break it out differently. So A, you have to have a qualifying disability. B, that has to have an adverse educational or functional impact at school. So if you get stuck at the eligibility process, it's usually on that B part, the adverse impact. And it's really important to kind of think about that as you go into that eligibility meeting. In Ohio, you guys call them ETR, which is Evaluation Team Review. Everybody's got to be different, and we call this alphabet soup. So what you get with an IEP is you get this document, and the document governs the special education. The big difference between an IEP and a 504 plan is that in the IEP, you get something called specially designed instruction. We call it SDI, more letters. Specially designed instruction under the law is supposed to be uniquely tailored to the student, specially designed for the student, and intended to help them make meaningful progress. So we get like really great stuff. I always think about your cute little kid, right? So when I think about my cute little kid, this is a better picture of his brother and a halfway cute picture of my cute little guy. But in this frame, I got a wonky frame situation going on. But when I think about my kid, I think about that cute little crooked smile and his blonde hair and his wild abandon. And I'm like, holy cow, school gives him specially designed instruction that is uniquely tailored to him, his crooked smile and his cute blonde hair, and intended to help him make meaningful progress. That's really exciting, right? And I used to practice in general practice. And that's very unique in the law to have that much girth in any kind of law. Most laws are like, oh, it's reasonable, right? But that's very specific language, which is exciting. And then with that, we make some goals, right? So we're like, here's our profile. Here's what we're good at. Here's where we struggle. And then we scoop up needs. So we look at what do we need, and we try to teach that by capitalizing on our strengths, right? So we scoop up the need and we try to teach that need by capitalizing on our strengths. And we take data, and then the data drives the instruction to say, oh, that's working, let's do more. That's not working, let's do less. Okay. That's in an ideal world. With the 504, okay, wait 1 second. Also in IEPs, we get things called accommodations and modifications, supplementary supports and aids. And those things are entitled to or are expected to or designed to support us such that we can access the general education, tier one education for all of the other students, right? Like that just regular general education. And so that might be, that you get like preferential seating or that you get extra time to take a test or that you get an aide to help you access curriculum or that you get special transportation. I mean, the list is like literally infinitely long, but those are some common ones. All right. So those are accommodations and modifications. Actually, all those are accommodations. We can also modify stuff. So we can like reduce the visual clutter on your paper. Your paper looks different than everybody else's. We can make your eighth grade science at a second grade reading level. It is literally different than everybody else's. You get 5 questions when everybody else gets 25. Okay, that's modifying. All right. So that's an IEP. In a 504, you don't get that specially designed instruction. You only get accommodations and modifications. So we'll wrap up here with 504s. 504, it's called a 504 because it's a section of a law, the Rehabilitation Act of 19. We argued yesterday about what the year is. I think it's 1975. Somebody can look it up. Um, and it's section 504 of that law. So um, what 504 is it is a law that prohibits discrimination. So, in pertinent part here, as it applies to special education, 504 prohibits the discrimination against a person with a disability by a school. Okay. So, it does a lot of other things in discrimination, but that's what it says in special education. I like to say the easiest way to understand 504 is with a kid with maybe diabetes. Maybe there's a school wide policy against food because food is gross and dirty and whatever. It's also necessary to live. But school says nobody can eat in this school. Well, a person with diabetes would not be able to access school if they weren't allowed to have food in school because food keeps them alive when their blood sugar gets low. And so we would write a 504 plan giving them access to food such that they could then access school because otherwise it would be discriminatory against them based on their medical condition. Okay. So I think that's like the easiest way to understand 504s. But with a 504, you get those supports. You can even get modifications, but you don't get that specially designed instruction.
Thank you so much, Ashley. Thank you for that. Um, I've put some links into the chat, everybody, so that if you want more information, we have a YouTube channel, we have the RAC website, and the Padlet. I think one of the points that we also made about the 504 is that this is a document. The IEP will stop when your child graduates or can stops receiving school age services. The 504 is a document that actually can help an individual qualify for services outside of school. So whether that be at the college level, I think that's the most probably common place that we see 504s, but you could also use a 504 in like a summer camp setting if you have a child again who has a medical need and you need to advocate for them getting that support. So, um, can you work with an intervention specialist on a 504?
I'm happy
That's a
to
question that Sarah, thank you.
I'm happy to jump in and answer that. I think like and my colleagues may have other answers. I think the answer to that is technically yes, right? And there are states where you can get a dedicated aid on a 504. Like the 504 universe is big, but it is an unfunded universe. There's funding attached to IDEA and IEPs, and there's not funding attached to Section 504. And so the team would have to agree. I think, I've worked with kids on 504 plans. I have a child on a 504 plan. I think at some point you may hit a tipping point where you're looking at actually doing an evaluation for an IEP. But I also like, you can ask for anything also. It's whether or not this school can be compelled or pushed to provide it. I have asked for intervention specialists off of IEPs. When I've asked for that, I've framed it as a request, as an intervention request, essentially. Like, can we assign an intervention specialist as response to intervention or as part of the 504 in this specific area and take data on that?
That is a really good segue. Maybe you can keep talking about this, Sarah, is, when you're making those advocacy requests, like what is the most effective way for a parent? Like we talk about, for example, the paper trail and how important that is when you're navigating either a 504 or an IEP. So what are some ways that parents can ensure that they're being heard and their voice is very much present in their advocacy for their child?
So I think a couple of things, and I'm sure other folks have good ideas as well. I think the first thing um, is just keeping in mind, like for me, a big red flag is whether or not the parent does not understand what's going on, and why that's happening. Because you should be able to read your child's IEP, their evaluation, their 504, and understand it without any of us in the room, right? Your school should be able to explain to you in language that you can understand what is going on with your kid, what they're doing about it, whether or not they're on the same page as you are about whether or not it's a good thing or a bad thing, and what solutions look like. And so I think one thing that I encourage families I work with to do is if you're hearing an acronym that you don't understand, ask um, the school to spell it out. You can ask them not to use acronyms at meetings just to make sure you're clear on what they're doing and that the issues that you're having are substantive and not communication based. Because I do think sometimes schools do a bad job of explaining what they're doing and why they're doing it. And so you may be more on the same page than you think you are. I think the other thing is that parents are really the experts. Um, or you're an expert in what's going on with your kid and what you may think need to happen. So documenting that and keeping track of that is helpful as well. And the things I love to see when I'm reviewing a file are not necessarily a parent who's used key legal terms, but a parent who's described what's going on, right? So instead of saying, looking up or Googling like the perfect legal phrase for asking for an evaluation, making sure you say, like, this is what I'm worried about, right? And thinking about where your expertise comes in as a parent for that, right? If your child is saying they don't have friends anymore, if they used to love school and now they don't, in addition to grades and concerns about progress are important. And then I think the last thing I would throw out is being expansive as opposed to restrictive on the data you collect, particularly if the school is evaluating. Um, I really like schools to do cognitive testing. I used to practice somewhere else, right? And I find particularly in Ohio, schools don't want to do that unless there's unless there's a clear cognitive concern. But the threshold when we're evaluating should always be like suspected, right? So I want to get more information rather than less about a kid. But so those are the three things I can think of quickly. I'm sure our folks have others.
Anybody else want to hop in on this?
The only thing I thought of while she was speaking was when you're concerned about are you really getting the opportunity to meaningfully participate in your child's meetings, I find it really helpful for parents to ask for drafts of things prior to the meeting, even if they can only have it a couple days in advance, to be able to read through it and come prepared, whether it's with an agenda you want to really use, maybe they give you an hour for that meeting. And so you want to make sure you have a lot to get through. And if they start the meeting with line one of page one and they're going to read word by word, you're probably not going to get through your document. And so if you have that draft ahead of time, you can read through, find the areas where maybe you're not sure what they're referring to, or maybe you feel like this looks okay, but what about this need my child has? Could we address that? Or I think maybe they need this accommodation. You can come up with your questions, come up with your feedback ahead of time, have your notes. I like to write directly on the draft, any questions or notes. So as we go through section by section, I'm prepared for what I want to ask. And that can really lead to a much more collaborative meeting when parents show up, where everyone else in the room has had their eyes and hands on the document and parents haven't. It can be information overload and you really need time to digest it. And so I think everyone can appreciate a more productive meeting if you just a simple request of, can I have the draft in advance so I can really come prepared to meaningfully participate, helps everyone. And so I always recommend that.
Can I weigh in on that also quickly? And so we started with Sarah's explanation about whether or not we could use an intervention specialist for a kid on a 504, and the answer is it isn't required, right? Like that was Sarah's answer. But we can maybe get access to an IS out of something that's funded out of a different box, right? So RTI or MTSS is can be a pathway to special education. It's funded differently. What I like to say is that in order to be
Really
effective
quickly,
advocates,
Ashley, what is
yeah,
RTI and MTSS alphabet soup?
respond.
Thanks.
Yes, and this is where we're getting, right? So response to intervention or multi-tiered system of supports. And it's not super important that you understand that now because it might not be applicable to your child. But here's what I have to say about that, because it's kind of intended to make you uncomfortable. I think in order to be effective advocates, parents really need to have a good understanding of special education law. But sorry, but I think you have to understand what your child is entitled to under a 504 and under an IEP, and understand the process. And there's all kinds of places to get that information, whether you like books or podcasts or online courses or whatever. Then I think you need to understand a little bit of special education practice. I think you need to understand what RTI looks like. Do you use a computer program? Do you use books? Who teaches it? Does it have to be a teacher? Is that an intervention specialist that offers 504? Like what kind of behavior supports are out there? What's the difference between neurodiversity affirming care and compliance-based supports? You have to understand a little bit of the nuance, whether we're talking behavior or we're talking reading or we're talking inclusive practices. Like, what is universal design for learning? And then thirdly, I think we need to have the negotiation and advocacy strategies to get our child what we think they deserve by way of educational practice under the shadow of the law, as I like to say. And I think Sarah's example was a really good way of saying, I understand what my child's entitled to get. And I understand enough about RTI or MTSS, whatever your district calls it today, or this behavior support or this inclusive practice or this thing, whatever we're advocating for. And now I want to talk to your values. I want to talk to your interest, to the school's why. So this idea of interest-based negotiation is like one of the best negotiation strategies that I think you can use. And so, kind of honing in a little bit on concepts of team building, organizational leadership, negotiation strategy. That's not special education specific. And some of the books on those things are really interesting anyway. And some of the podcasts are really interesting anyway. I think that's a place where parents don't spend enough time.
That conflict resolution, it is unfortunately whether it's positive or negative, typically there's some sort of conflict or discussion of resources or something. So I do think it's good to come to the table with as many tools as possible, right? I'm reading the comments. Thanks everybody for sharing resources. I love to see that just partnership in the chat happening. I'm thinking about Stephanie and Sarah. You guys work with some pretty complex kids. And one of the things that comes up on a really regular basis with families when they have a child who's on an IP or a 504 are those transitions. Whether it be a transition from a teacher to another teacher, or from a building to another building, or from one grade to another grade. What do you think that these families can do, our families can do to support the most ideal transition from one team to another? Because it happens and we see a breakdown. People aren't reading the IP or the behavior plan isn't being followed, right? And this is typically things that I feel like if we plan more intentionally for those transitions, we can be proactive around, right? So I'm getting a thumbs up. So do either one of you kind of want to talk about what you've seen work and
Yeah, either
So
one of us can. I think everybody on this panel and probably everyone on this call has great ideas in this. This is not something that attorneys bring anything unique to. A lot of great parent advocates in this space, and just parents know what's going to be best for your child. And I think that again goes to Ashley's point about how those transitions are individualized. Are you someone that knows your kiddo is going to need to go see the school, for example, when nobody's there? Have a chance to tour it and then slowly integrate. Are they going to be able to just jump right in? Are they someone that's like, nope, this is going to be fine? Very much, I think it depends on the student. And so what Sarah and I do at Legal Aid, as Amanda said, we do work with really complex kiddos. A lot of times we work with kiddos that have experienced significant trauma that come with all their other disabilities. They also have a PTSD or other sort of trauma related mental health condition. And so we, I think, really work with their teams to get feedback from parents, from caseworkers, from mental health therapists, and find out what's best. So there's no real magic. I think it's just really just listening for each child and the team surrounding them about, hey, here's going to be some good ideas. And then to Sarah's earlier point, just asking, right? We often don't have the luxury of being we have to just get in there and ask and make it happen fast, because a lot of times our kids might have needed an IEP 4 years ago and nobody got around to doing it. And so now we're going to be in there and we're going to be moving really quickly, and we're going to need to just make some of these things happen. But I'm sure other panel members maybe have concrete ideas, or folks on this call could throw things into the chat just about those transitions.
I think the visits, that's something that a lot of times families don't think they can ask for. And even, sometimes if you're in a big enough district, they might be like, well, we're transitioning to this building, but there's actually three other buildings. And you actually have the option of maybe seeing which one would be the best fit, even if that involves special transportation, right? Like if this building has a better, classroom fit and dynamic, sometimes that works. So,
I mean, Amanda, that's a really great point, but I think it's also a cautionary point a little bit, because
mhm.
there is some law that of course supports districts in saying, wait, these are all elementary schools. What are you saying? And so when you're making those specific asks, being able to say why your child needs that very specific program at that very specific school. Why is that other elementary school not good enough, right? Like, what is it? And being prepared to know that you're going to have to make that argument is really important, because unfortunately there isn't just this like, well, but parents should have choice. That isn't where IDA or 504 gets you. It doesn't give you that level of flexibility. And it looks like Ashley's ready to jump in. Go ahead, Ashley.
So I also think it's really important, especially in that discussion, to state, like, sometimes as attorneys, we're really good at stating the thing, like setting the boundary. And so for all of you parents in parent land, what you might not know is there is a subset of people that is like inclusion, 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 homeschool only. And there is a subset of people that is like specialized school, specialized program only, right? And there are billions of people, or at least millions, in between those two positions. But it's really important to say at the outset, listen, we do not think that you are going to be able to meet our child's needs at their home school, and we therefore would prefer a specialized program. Or we are very reasonable, but we are very inclusively minded, and we really feel like you can meet our child's need at their home school, or something in between, right? Because schools don't know you. And so step one, tell them what you want and be very clear about that. And then step two is also the why, and do your research so that you've got that. An example that I have is when I thought my child had ADHD, I waited through kindergarten 1 and kindergarten 2. And then I was like, okay, we need to get him some supports, and he's young, and the doctor's probably going to be like, we don't do this for a couple more years. And so I went in with a one pager. I had done my research. What's ADHD look like? It looks like these characteristics. And then I had a little indent on every single one of them. This is what it looks like for my kid, so that it was organized. It was straightforward for him. I didn't have to say all the words. I didn't have to get all emotional, because it's hard to advocate for our kids but I went in with my argument. And you can do the same thing for anything at school, but this transition thing is really important. Another thing really quickly about transition that I would say is there's also reason to get the decision quickly because most of our kids really want to know. If we want to know, imagine about our kids because we've been through school. We at least know what school looks like. In a lot of cases, they don't know what middle school looks like. They don't know what high school looks like, and they're anxious disasters. And so so we can say to school, listen, I know that you don't make these decisions until July, but it would be really helpful for my child. And this is what like the psychosomatic waiting impact is, right? Like we've got ticks and we haven't had ticks in a while or whatever. And if you convey those things, obviously within the boundaries that are appropriate for your child, right? Like without violating them, what you're doing is you're provoking empathy, and empathy works. You're talking to educators, right? Like they went into education to help people.
Thank you, Ashley.
I just want to jump in just with two things to Ashley's point, which is that in terms of complex cases, but I don't think this is limited to the cases that Steph and I work with. We do also work with kids who are going in and out of hospitals, and sometimes residential treatment, or are transitioning campuses. And I would say one of the most helpful transition things I've asked for is if the child has a strong relationship with a teacher or staff member, seeing if that teacher is willing to do a phone call or a check-in with that child when they're in the hospital, when they move to the other campus, a special visit, something like that. They've never said no, ever. And so I think that's just like an easy ask. And I do, I also just want to, I am the parent of a child with a disability. I work with a lot of parents of children with disabilities. And Ashley, you have a gold standard when you go into meetings. And I am just going to come in on the other end of you and say that, like, we work with folks who have very limited resources. If any of you are feeling like I'm not going to be able to advocate for my kid because I can't do a one pager, like whatever, your best is enough, right? In terms of going in and advocating for these kids. And I think what I see on the flip side is parents who have not felt comfortable speaking up because they don't feel like they're educated enough. And so they haven't like said, I'm concerned, right? Or they haven't said like, I need you to be doing more. So please don't let the perfect be the enemy of the good here.
That's a great point.
Well, I think the
Go ahead.
overarching takeaway here on the issue of transition is that you can ask. So many parents feel maybe the IEP cycles from November to November, and so they had their IEP in November. We're not thinking about transition maybe until January, February, March time that we're looking at now. You don't have to only have meetings annually at the IEP. It can be a great time to say, let's reconvene in March to come up with a transition plan for my child. And then all the things that have already been shared. Here is why, and here are the specific things I'm looking for you to address in a transition plan for my child. But you can ask for that. Ask to say, let's even, some districts I've seen will make transition plans that are attached to the IEP and based on your child's individual needs. That's the beauty, that's the strength of the I in IEP. It's individualized to your child. But let's have a meeting to discuss that so that we can make specific who's in charge of this particular transition activity, who's going to take my child over to tour the new building, who maybe there needs to be a social story written, who's going to write this social story, and when are these things going to be done? And so you take these ambiguous ideas and put them into a plan, and it's more likely to be implemented.
Accountability is key, Jenny. Thank you for that. And coming up with a plan and actually saying, assigning like this is what's going to be done and by who and by when is a huge missing link that oftentimes causes there to be a lack of progress, right? If we don't have that accountability and that follow-up. I do have a question in the chat from Cassie just talking about classroom observations. Now, this is across the board. I will say in the future, we'll try not to mention specific districts, but it's just going to happen. I know it is going to come up. But This has been in my experience. I mean, I've had different experiences based on the district, based on a building within the district as well, whether they'll allow me to come in and observe or a parent come in and observe. Is anyone willing to take on this question? So I'm a parent advocate, have a family that's transitioning to a new school for middle school. They've been asking their district to observe a classroom to see if they would feel like it would be a good fit for their child. And I've been denied multiple times, even while they are escalating it up the chain. School is claiming it's a breach of confidentiality for the students. How would you recommend navigating this? Or if the district rep says no, is there any way around this? This is a tough one, guys. Look at that. Ashley said not it. I love it.
I can
I
win. So sorry,
hilariously, I know this is a super common issue. I don't have a tried and true practice because I have never run into this in 20 years. I have ideas, but somebody else probably has ideas that have actually worked.
So I actually in DC was one of the attorneys in DC where I worked, there is a law that allows observers into classrooms. And I was one of the attorneys on a case where the school district still refused to let an observation in. So this is like a sticky issue.
Hmm.
Um, I do think if there are other students in the like I think it depends, Cassie, and I'm happy to talk to you a little bit more about this offline because I think the facts that I would want to know is has this classroom been proposed as part of an IEP? Is there a way to tour the classroom without other students being in the classroom? Um, is there a dispute about whether or not the classroom, like where I've pushed for observations is where I've said in a nicer way than I'm saying now, like, I don't believe you that this is a specific type of LRE, right? Like, I need to see X, Y, and Z, right? Like, what you're describing is not sufficient for me to think that it is meeting what you're proposing as a placement. Um, but I think if you're able to if you're able to come in a more neutral way, to find a way to see the classroom where kids aren't in there, we're like entering the spring, which is like the season of open houses. Thank you, Amanda. I'm so sorry.
Okay. That's what I'm going to do.
So if they're open houses, if they're parent teacher conferences in the classroom, right? If there's some opportunity to observe it without children in the classroom, that's you might want to see if that's a way to get into. But you can, I think you'll have all our contact information. I'm happy to brainstorm more and also send you the case. Although it's in DC where there is a law, so that's not super helpful.
This can also be, I think it can be impacted by the teacher and the staff in the classroom. And this is something that probably you will not hear about from an administrator because they're playing that middleman role and they're being, protective to a certain extent. So sometimes if you're getting resistance, it's because the classroom staff are actually the ones who are like, I just really am not comfortable having someone in here. I already have my hands full. I'm overwhelmed, you know. So there could be a lot of things at play that is not just the district being difficult. So I always say, get to Sarah's point, like ask questions, get curious before you get furious. Don't assume that the district is trying to be contentious, but actually ask questions and say, is there another way? Can we be creative about how I can get, my anxieties addressed? Stephanie, I saw you hop off mute. Did you want to add anything? Okay.
No, I mean, exactly what you said. I do think a lot of times it comes from a teacher that might just be feeling overwhelmed. I do think it's concerning though for parents because the reality is that most of these classrooms do have folks visiting. To Sarah's point, there are open houses. There are ways that these classrooms are more open. So if you're really getting the sense that, it's a very exclusionary environment, I think you should be sharing that and say, it's really hard for me to commit that this is the right LRE when I can't really have any opportunity to see this because even, I think I've seen this come up in Cincinnati Public a few times. I know, I mean, you said not to bring it up, but it's usually able to be worked around, I guess is what I would say. And you should be able to have some opportunity to observe and to tour and to make sure that you're going to feel comfortable with a building, with a classroom.
And
Thank
not
you,
only
Stephanie.
that, but what are you if what like whatever the school is trying to protect, um, then how would I prepare my student for that? So I did have a client who had not ever been in a self-contained classroom. and was using a self-contained classroom more like a resource classroom. So they were just going down there for a couple of class periods in an upper grade level. And in the self-contained classroom, there were 3 students that had medical things that would flare, like a seizure kind of a thing. And this student had only ever gone for their special education minutes with kids with dyslexia and ADHD and not a whole lot of medical impact. Well, the if this had arisen and the parents had said, "Can we look at that environment?" and the school had said no, that would raise a red flag for me, like, well, what do we need to prepare the client for? Because this client of mine really struggled going, like, transitioning into that classroom. And then finally, when we asked, they said, so and so sleeps a lot. And we realized that this child was having a seizure almost every single day. And it was really scary for the little girl because nobody had ever thought to teach her what seizures were, what the teachers were doing, all of those things. It was super overwhelming, right? So, like, at the end of the day, we're here for children and we have to prepare children for things. So if there's something that is worrying you, think about the impact on the child that's going to be there between the hours of 8 and 3. It's a long time.
I think I've heard a theme coming from all 4 of you, and that is, when you're advocating on behalf of a student, to really focus on this being in the best interest of the kids, not best interest, but this is what the student needs, right? This is what's appropriate in order for them to successfully access education, right? So not basing it on maybe your, like, the parent or the caregiver's desires, but really shifting and focusing on what does this child need, right? Even if it will make you feel better, obviously, and naturally as a parent or a caregiver, right? If your child is getting what they need, you feel better too. But the district really needs to hear that this is focused on what the child needs and not something that a parent needs, right? I do want to jump in, and Jenny had sent me a document ahead of time. So if you don't mind, I did add this to the Padlet. I put links to the Padlet that has resources for everyone on the Zoom and anyone who wants to share that Padlet out. But just talking about behavior, this is something that comes up on a regular basis. So one of the things that has come up recently that I've been hearing about and parents have been contacting is, um, what are the limits to a kid being sent home? Um, what if a district, is not necessarily documenting that as a suspension? Like, what does a family need to know about behavior, and if their kid is being sent home because of behavior that is going to support their kid ultimately in accessing the most appropriate education? And Jenny, if you don't mind kind of kicking us off on that one, I know all of us can have opinions about this one too.
Yeah, well, and this one can get into all kinds of things and procedure, and so it could be really lengthy. But at the start, if your child is being sent home for behavior, one of the first things I would be asking for is documentation of that, and are they choosing to suspend? Um, Sometimes we see districts just choosing the "I'll send them home," and doesn't everyone feel better? Um, because your child's having a hard time, but don't worry, we won't be suspending them, because suspension can be a scary word, and concerning for parents, rightfully so. But unfortunately, what that's doing, especially if your child is on an IEP and it's not being documented as a suspension or an emergency removal, which still counts as a suspension day, if they're not defining it and documenting it as such, how long could that continue without really any response or action on behalf of the school district? And so, my first question is always, if they're being sent home, I'm assuming you're documenting that as a suspension. And the reason why for that, for students on an IEP, is that there's procedure in place. So students on IEPs can be suspended the same as their non-disabled peers up to 10 days cumulatively, um, without any other action. But once we hit those 10 days, then it kickstarts something called an MDR. Here we go, another acronym: Manifestation Determination Review. And in that, which is the document we added to the Padlet, the document that the IEP team goes through when you hit that manifestation determination review. When you have that what you're trying to get at is the behavior that caused your child to be suspended now for those 10 days, is that a result of their disability? Is it directly related to their disability or not? And the team has to come together and determine that. So if they're not ever counting the sending home as a suspension, you're never getting to that process. And ultimately, if the team determines that, yes, this behavior is a manifestation of their disability, then there are certain things that the district is obligated to do to help your child with that behavior. Namely, here comes some more acronyms. Developing, if one is not already in place, a functional behavior assessment needs to be completed. And when that's completed, then you create a behavior intervention plan. And that's really important if your child is struggling with behavior that's keeping them from their learning and making progress on their goals. The team needs to not just be reactively sending them home, but they really need to be addressing it. What's causing that? And how can we help this kiddo with what's going on that's leading to behavior that's to the extreme that they need to go home? And so we really do want the team to be addressing that. And there's all kinds of procedural things, and maybe one of the attorneys wants to talk about it, or I can get into it. But there's a lot of things. There's the process of specifically what you go through in an MDR, and how to come prepared for those, because they are really important. They can determine whether or not your child's returning to school, or if maybe they get placed elsewhere. There's questions often parents have of, well, if they determine it wasn't a manifestation of their disability, is the school still obligated to provide the special education services? The answer is yes. But there's all kinds of branches of places we can go on this topic. But I'll stop there and see if anyone else has input they want to add.
Here's a big question, and one that comes up on a regular basis. So it sounds like you can suspend a student on an IEP, right?
Yes.
Can you expel a student on an IEP?
Yes. So, yeah, and
But
that
there
is,
has to be notice, right? There's a process and there has to
yeah,
be, okay. And this came up, just so you know,
yeah.
in a prior meeting and last year, a couple of times where a family was asking, like, the district is attempting to expel my student, and there had not been an MDR. And I think that's just the manifestation determination review is like the most important key, like, term that a
Yeah.
parent can use in that situation, I think.
Yeah, you should definitely be asking for that if they're threatening expulsion and they haven't completed that. That's number one, and I recommend you come prepared to that, especially if you feel like there's some nuance there in the behavior that maybe the team doesn't readily understand. Having a letter from the physician or an outside therapist who treats them and says, yes, because of their disability in this way, you might see XYZ behavior. Having that type of input can be really helpful in your stance if you feel that the behavior was a manifestation of their disability. So you want to come prepared to that meeting. You're going to, in general, when you go to an MDR, they're going to discuss the incident or the behavior that led to the suspension. Then they're going to talk about the nature of the student's disability. And then they're going to ask some questions. They're going to make sure that the team reviewed all relevant information and that the parents and teachers were heard. Did the two big ones, did the team review the student's IEP in their file? And so is everybody on the same page here about what's happened? And then kind of the two big questions that they ask is, was the behavior directly related to the disability? And then the second one was the behavior a direct result of the district's failure to implement the IEP? If there's a yes to either of those, then the team says, okay, it was a manifestation of the child's disability, or we failed to implement, so now the student can return to school. if that doesn't happen, then they can move forward with expulsion. If parents disagree with that decision, they can ask for like an emergency review of that. Either way, if they do decide to place your child outside, it is a team decision of where they go. And what was my other thought? And that once you've gone through that process, there's always another step, right? To ask for an appeal. Oh, but I lost my train of thought. Does anyone else have something to add on that?
I do. And I want to add sort of a grimmer perspective,
Yeah.
which is that like there are two buckets of rights that come into play when a child is recommended for expulsion. One is the child's right to due process, and that's handled at the expulsion hearing. And one is the right of the educational decision maker of the child with a disability to not be removed from school as a result of their disability. And exactly like you said, Jennifer, what needs to be determined first is whether or not the alleged conduct is related to the child's disability. And if it is, the child, the school may discuss other things. Maybe the kid needs to go to a different type of program, but they can't expel the child. And if you disagree with the manifestation determination, you can request an administrative due process hearing. Expulsion in Ohio, once you are kind of barreling down the road to an expulsion hearing, though, options are more limited. And I'm going to do like a 30-second overview of expulsion in case that's helpful. In Ohio, it can be 80 days to a year, sometimes longer now, with no access to educational services. If you have an IEP, you can get some services. And there's not a true legal standard that's used in these hearings that varies state to state. In DC, the legal standard is beyond a reasonable doubt. Actually, it's the same standard that's used in criminal cases. The school has to prove that the child committed the conduct. There's no such standard here. It's really, the school has a lot of discretion in terms of deciding whether or not to expel the child and for how many days. And once a child has been expelled, the only appeal is to the school board. And then to common pleas if you lose that appeal, but it's not, and Steph, I think, can speak more to the common pleas process. It's something you really want to avoid. Like my favorite expulsion hearing is the one I never make it to, because once you're there, you're in some trouble. And expulsions are recognized by other school districts. So I think sometimes parents don't always get that information at the outset. And it's, when someone's calling after a child has been expelled to get legal representation, it's really hard because there's a lot that we can and can't do. I think the other thing I'm going to throw out, since I'm like just throwing storm clouds everywhere, is that expulsion hearings are not private. And so if there is the potential for criminal charges, you also want to be really mindful. And the potential for criminal charges, particularly with online threats, is wide ranging. So you may also be limited in like how you want to advocate at an expulsion hearing if there's a companion criminal case. We have had great luck talking to kids, public defenders, and kind of brainstorming with them about what to say. So if you have a kid who's facing that, like don't lose hope, but you do want to make sure you're talking to the kid's criminal attorney about what they should and shouldn't say at the expulsion hearing. Steph, I'm sure you want to say more.
Yeah, thanks for taking over on that. That's usually the point where, as a lay advocate, I have an attorney getting involved at that point. We're making that recommendation. Oh, but the thing that what I did want to add was the three things that trump any MDR decision, which is weapons,
serious bodily injury. And
drugs, and serious bodily injury. That was what I was looking for, that I wanted to add as my final thought, that those things, even if it is determined to be a manifestation of a child's disability, those three the big three are the no-go. So
You reminded me of something else too, which is that we've been talking about manifestation. If your child has a 504 plan, they're entitled to a similar proceeding called a causation. And if the child is suspected of having a disability, that criteria is narrow. But even if they don't have a 504 or an IEP, if you've been asking for an evaluation and the school hasn't responded, they are eligible for the same protections. And you really want to throw as many meetings as possible between you and an expulsion hearing, generally.
That so that's really great. I was gonna add three. You just took away one, which is awesome. Something else that I do the second that an MDR referral comes into my office is I ask for the medical stuff because a lot of these diagnoses, like if it's just ADHD and your pediatrician has done a Vanderbilt and given you some Ritalin, which happens a lot, not as often anymore, but it still happens quite a bit. What I'm looking for is I'm looking for that word impulsive because if a child exhibits impulsivity, which a lot of children do, and impulsivity is a symptom of a lot of different diagnoses and conditions, then I can almost always tie or make a good argument that something is a manifestation of their disability or connected to their disability because they were acting impulsively. So I almost always ask for the medical records. Another thing that I do in MDRs that I think might be something unique, but it's really effective is I also go into the school's handbook because now the caveat is I'm an attorney that no longer does civil practice. And I always say, I want to win because I'm right. I don't want to win because I do paperwork. So in common pleas cases and car accidents and the things you see advertised on TV, big law firms will shoot down little guys like us by giving us a billion things of paperwork, and then we'll make one little mistake because we're little and we can't keep up with them, and they'll slam us with the one little mistake, and then our clients lose. Okay. So I don't want to win because I'm good at paperwork. But when you go into those handbooks, they have definitions of these things. You can pick apart the definitions and it can be very, very impactful. So, is it terroristic threatening? Is it a level 1, 2, or 3 terroristic threatening? And a lot of times it has to do with the reaction of the other peers. And you can go in, there's almost always statements in the school's packet, and you can go in and see if anybody says, I was afraid for my life. I was this, I felt this. And you can kind of, tear that apart, so to speak. You can unravel the school's case for expulsion in particular by looking at those definitions. It seems like it's really complicated, and it's not. Actually, most of the time, parents are better at it than I am because I'm like, yeah, well, this said this, and they're like, this is what it means to be afraid. So looking at the student handbook that handles discipline can be extremely effective.
Thank you. Stephanie, did you have something to add to any of that? I'm going to link the CPS Code of Conduct. I'll tell you, Cincinnati Public Schools has a really thorough code of conduct that I can tell you I have referenced many times, and has really, really specific information in there. Not every district has one that is as specific as CPS is, but I consider it a model for how to be able to set parents up to know what to expect when it comes to dealing with behavior. And then from there, it's just a matter of following through with what's written in the book, right?
I don't know, Amanda, if anybody has any questions about discipline, I think the panel did an amazing job covering it. We prioritize these cases at Legal Aid is maybe what I would just add because they are so complex. To Sarah's point, this is where everything goes sideways, and all that great work you've done to get that child the IEP, to get the child into that placement can be lost in a heartbeat, really. There are a lot of opportunities and discretion for school districts to find ways to try to push a child out during the discipline process. And we think it's really important that attorneys be there and that we be there for our clients early before the manifestation, because to Sarah's point, our goal is to not have our kids with disabilities have to go through the hearing for the expulsion, because the discretion, I appreciate Ashley mentioning about the code of conduct. You would be amazed at how creatively school districts, when they want to get your kid out, will interpret that code of conduct to make sure under Ohio law, which is very, you just got to lowest standard to be able to show that they violated some aspect. And even a great code of conduct like CPS is so flexible that for the slightest violation, there is enough to have that child out on expulsion. You don't, you would think that it would be like criminal law, and the only reason the kid's going to go out is if they've done something that's so serious. But it could be that they disrespected a teacher. That might be in your code of conduct to level 1, and there still will be discretion that in the right circumstance, an administrator and a hearing officer could decide that kiddo is going to be out. One thing I did want to circle back to is what Jennifer said about even if the child is expelled, there is this right with an IEP, which is different than a 504 plan, to receive FAPE, and that the IEP team is going to determine what FAPE is. And this is where we see a lot of parents that come to us really feeling pressured to have it be decided after a discipline incident, after there's an expulsion, that FAPE is home instruction, which it almost never is. But we will see districts say that is what FAPE is. We're going to give you home instruction. Parents have a lot of rights during that process to really change that outcome. But it can, without an advocate or an attorney, it can be pretty difficult. And it's really important to recognize, though, that you are still one of the partners and one of the people that is part of that IEP team, and that you should probably be very thoughtful before you just agree to home instruction as what the child will receive while they're out on discipline, if you do end up at that point, unless you feel confident that that really is FAPE for a child, which again, we almost never see a child at home instruction. It's really one of the most, if not the most restrictive placements, and it often cannot meet the needs they have.
Thank you. And I also have just noticed, anecdotally that it's really hard to actually secure home instruction from a district perspective. They're having a really hard time finding qualified people who can provide specialized instruction to people on home instruction. And then even if they can find that person, does it fit the schedule of the family? Like, it's just really complicated. It rarely happens. I agree with you that I've rarely seen an ideal home instruction unless it's with a kid who has like a medical condition, right? No behavior, no specialized, instruction. So, we're getting close to a time when we're going to wrap up. I'm going to see if there's any questions that are unresolved in the audience. I think we have a lot of resources. We've covered pretty broad ground. If we want to go around, and if there are questions, if you want to put in the chat, if you want to go around, if there's anything, Jenny, Ashley, Sarah, Stephanie, any parting just thoughts or things that we didn't hit that you just want to say, be sure to keep in mind. So for me, it would be like ESY season is upon us. So get ready for those meetings, get yourself organized, right? We could have a whole entire meeting just on ESY. So Jenny, any parting thoughts you want to share?
The only thing I was thinking of in as part of that behavior and MDR conversation is let's jump ahead, hopefully, or behind 5-10 steps, and really encourage you to think about if you're seeing increased dysregulation or struggle of behavior in your child at school, but they're not getting expelled, but it's starting to, maybe you're getting a few more phone calls or emails. That is a great time to ask the team to come together now. You can ask, and Ohio just put out a great recommendations on this as a state, that to complete FBAs at any time. A student doesn't even have to be on an IEP to complete an FBA. Again, functional behavior assessment, where you have someone come in and observe your child and see what is the function behind what's happening. Is it happening at a certain time of day, or with a certain teacher, or what have you? Let's get our hands on what's going on before we end up in MDR situations, and let's get it documented well in their IEP. There's a little box that says my child has behavior that's impeding their learning or the learning of others. And if that's really happening, I've seen kids who are having lots of struggles and the team doesn't want to check that box. And I say, let's go ahead and do that, because should we end up down the road at an MDR, we can't say we didn't know that something was going on, and it can be a great encourager for that FBA as well. So let's try and get ahead of things whenever possible and avoid avoid the messiness of expulsion and suspensions and all those things.
Thank you, Jenny. Absolutely. Ashley, any parting thoughts?
I think if there's ever a parting thought to give to parent advocates and other folks in this community, it is communicate, communicate, communicate. So most attorneys say document, 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 and I also maintain that. But at the heart of it, before Congress writes any law, they do a lot of research. And that research then fuels the law. So that's you get a bunch of whereases in at the beginning of law. Whereas we have found this, 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 and this. And one thing that Congress found, and they have made very clear, is that when parents are involved in children's education, the results for the child are better. And so it is really important. It is imperative. And there are, in fact, lots of cases that say the parents had the opportunity to be involved and they didn't, and therefore we're going to do what the school wants to do. It is imperative that you have relationships with school and that you communicate. I have a trillion resources over at the Collaborative IEP on how to communicate and when to communicate and what to communicate and that sort of thing. But just like Sarah said, it doesn't have to be all that complicated. Just remember that the IEP document is a year-long document. We set goals that we think a child can reasonably accomplish within a year. And it is absolutely preposterous to plan for the education of a child with a team, a very well thought out and developed team, and to not talk to any of the people on that team for an entire year. When we take data and the data gets exchanged and the data comes home to the parents, and for there to be like absolute crickets, that is crazy talk. So communicating is the number one skill and to-do checklist item, in my opinion.
Thank you so much, Ashley. Sarah and Stephanie, any parting thoughts you want to share?
I think the two things I would share is that when, like, something that I find is helpful to keep in mind as an advocate, but also remind families I work with that if you're hiring an advocate or working with an advocate, we are entering in for a brief period of time into a like 12 to 14 to even longer year relationship. And so like my job is to figure out how to get you what you want, but like also our collective job is to figure out like if you live in that district, if you're staying in that district, like how to do it in a way that allows you to maintain that relationship. And then the other thing I just want to share as a parting thought, because we've talked a bit about behavior today, is there's a psychologist called Ross Greene, who I suspect some of you may be familiar with, who talks about kids with behavioral problems, and he categorizes them as lucky kids and unlucky kids, and the unlucky kids are the kids with the externalizing behavior. So I found that to be like a helpful way to frame in terms of like our kids who may be more complex or have behavioral problems that can be more frustrating, is that they're not their behaviors are not more extreme. They're just less lucky than the kids who have an easier time managing their behaviors in school for one reason or the other.
Thank you, Sarah.
Nothing really to add, Amanda. It was really great to be with you. We really appreciate the invitation and just want to be a resource for families. If any, I think there's some professionals. I know we see at least a parent surrogate on here. If there are ever families that we can help, because this is a very overwhelming process. I think, even panelists, those of us that might have our own children with disabilities, very overwhelming for us to do as attorneys. And so we want to help parents just have as many resources as possible in our community, and appreciate the opportunity to be here today.
Thank you, Stephanie. All of you are such fantastic resources. I do have one question. There's a couple of questions. So if anyone has any 504 supports and resources that you feel like could be helpful to Tyler, it seems like that's something that he's going through. Tyler, I will let you know that in Ohio, when a family typically is looking for support, my first recommendation is to go to the Ohio Coalition for the Education of Children with Disabilities, which has a ton of resources. It's on the Padlet. I've linked the Padlet, and there are resources around the independent evaluation. There's resources around extended school year services. Ashley, thanks for spelling out my acronym use. We all have to keep an eye on each other when we speak in acronyms all day long. Advocacy in Action is a group that you can reach out to. We meet on a monthly basis. So if there's an ongoing issue, the Regional Autism Advisory Council helps support the maintenance of a list of IEP advocates, both lay advocates and special education attorneys. If there's someone that you want to speak to, when you're asking questions around, more like informational questions, trying to figure out what is an IEE and what are my rights around that. Like I said, my first recommendation is if you're looking for just that information to go to Ohio Coalition for Education of Children with Disabilities, they have a bunch of fact sheets. They have templates, they have resources. The Ohio Department of Education and Workforce actually also has a lot of resources on their website around this. But if you're having a specific issue or need for support, you can always reach out to either Sadie or myself. This is why we do this group, is to provide the support. So thank you for putting a couple of 504 resources in there. I do, like, if anybody wants to take on this question where a family is asking for information about a goal and they're not getting any answers and they're wondering if they're not asking the question the right way. Any recommendations around this in terms of getting a response? Ashley, go ahead.
A lot of times I think it's a lack of knowledge on the school district side. So they might not be, they might not know what you mean when you are saying neurodiversity affirming. So maybe find like a resource online. If you do not know Lisa Baskin Wright, I will put her information in the chat. She does a lot on writing neurodiversity affirming IEPs, and Dr. Taylor Day. Both of them have Instagram accounts that you can find, and they've got like free downloads. Maybe attaching one of those like 4 or 6 page downloads to an email would be helpful so that you can educate the district on what it means to you to be a neurodiversity affirming district. So Amanda, would it be okay if I put my email in the chat? Because on that one, I'd be happy to connect you with both of those ladies.
I would love it if all of you, if you're comfortable putting your contact information in the chat, I think everyone would really appreciate that. And we'll be sending out that follow-up information as well. We have information in the Padlet. I can put links to websites as well, just so everyone has access to contact information.
Okay, I just dropped mine in there. So if you contact me, then I can get you the handles for those 2 professionals and see if that's what it is.
Thank you so much. Thank you, Sarah, for adding that. I have put links into the chat that has the Padlet. It also has the recordings of past sessions. So one of the questions around ESY, I did link. We had Jen Powers Algie from the ARC of Ohio actually present on summer and ESY last year. There are other resources out there around ESY. And then the Padlet also has resources around ESY as well. So you have access to that. I'll link these things again. I want to remind everybody that this is a monthly event, and we're happy to host another panel next month that is really going to be around just disability, navigating resources, disability resources. So our next event is actually on March 26th. It is on Thursday. Again, it's from 3:30 till 5. And we are going to be highlighting a couple of different organizations and just talking about disability awareness and resource navigation. I have noticed that there have been some questions around that in this chat even. So if those are questions that you still have next month, please join us. These are recorded. Feel free to share the information. The Padlet, the videos, all of these resources are created to share out. So you do not have to attend the events to have access to them. And of course, if you want to be added to the mailing list, please let RAC know. if you registered for this event, so that we can put you on the mailing list so you know of future events. We usually take off a couple months in the summer, but we've been doing this every month. So thank you all so much for joining us. Oh, thank you. Sadie, I think, yeah, RAC, RAAC _ Sensi at uc.edu. And thanks to my co-host, Sadie, who is here in spirit and with her camera off because she had a big event last night. They had a big fundraiser last night. So thank you so much for even offering the space for this group to meet and to provide this resource to our community.